Sher, and I'm an associate attorney in the estate planning section of Sessions Fishman Nathan in Israel. I want to talk a little bit about philanthropy and estate planning today. A lot of people don't really know how they work together, and philanthropy is a really important part of estate planning. Philanthropy is making gifts to charities or other good and welfare causes, and a lot of clients give annually or even just in small amounts, and so we always ask our clients which charities they support and if they're interested in philanthropy, and most of them say yes. A lot of people have specific charities that either they serve on the board for or they make annual contributions for, and then there's people who just give if their coworker is fundraising for a charity or running a race. They'll write a check to the coworker, or they'll donate to a friend's kid's sports team. And so we want to make sure that we discuss all of these things with our client before we draft any documents for the client. Especially clients who are aging, a lot of times they're thinking a lot about what their legacy is going to be. And we want to make sure that we help them to assure that they'll be remembered in a certain way and that they'll be able to continue helping out the charities that they're currently helping out now. A lot of our clients are really philanthropic, and so it's really fun to work with them on their charitable giving. And one thing that's really important for people to know is that there's some really great tax benefits to philanthropy. So we can accomplish the client's philanthropic goals, and we can also save them some money in taxes. One great thing that a lot of clients like to do is they like to leave bequests in their wills to charities that they've supported over their lifetimes. And what we do with these clients is we try to find out what their estate's going to be valued at as of their date of death. In Louisiana, the amount that can pass from an estate to an heir tax-free is over $5.4 million of assets, which is really high. But there are some clients who do have estates in excess of the $5.4 million. And in their case, what they can do is they can leave assets valued at $5.4 million to their heirs or to anyone they want to leave them to if they've got a carefully and properly drafted will, and then anything in excess of the taxable amount, and it changes every year because of inflation, so next year it could be more than $5.4 million, and it'll probably keep going up a little bit. And they can leave whatever is in excess of that exemption amount on their date of death. They can leave it to a charity. And if they leave it to a 501c3 charity, then they'll be passing the amount that's below the exemption. So in this year it would be $5.43 million. They're passing that tax-free to their heirs, and then anything above that is going to a charity. So not only are they passing significant assets on to their heirs, but they're also giving a great gift to a charity, and they're not paying any estate taxes. Charitable remainder trusts are a tool that we use a lot here to help clients give to charities. With a charitable trust, it's something that we set up in our office, and there's a couple of different kinds of them. So based on the client's need and the situation, we would draft one type of charitable remainder trust. And once the trust is set up, the client will donate an asset to the trust. And the asset could be stock that pays dividends or real estate that is rented out, so there's rents being paid on the real estate. And when the client makes that donation of the asset to the charitable remainder trust, the client will get an income tax deduction on the value of the asset that's being transferred, which the client should be happy about, especially if it's a large asset. And then the client will receive income from that trust. So if the asset in the trust is stock, then the client will receive dividend payments, and depending on the terms of the trust, the the client could receive a fixed amount, or the client could receive a certain percentage of the value of the asset in the trust. It just depends on what type of charitable remainder trust we set up. And then after the client's death, that asset that's in the trust, so the stock or the rental property or whatever asset is in the trust, goes straight to a charity or charities that the client has named in the trust to receive the asset. This is a really great tax planning tool because the client gets an income deduction right away as soon as the gift is made to the trust. And then once the client dies, that asset is no longer considered a part of the client's estate. So if the client has a large estate that's going to be taxable, it'll just be one less asset that's going to be taxed with the client's estate. So these charitable remainder trusts are great estate planning tools, and we love working with clients to help them give to charities of their choice. And if you have any questions about planned giving or charitable remainder trusts, please contact me.